indecency and obscenity, that's what you do about treason, that's what you do about libel, and you have these questions here too. But people are really, as Peter made clear, unfamiliar with the decision about how to make these decisions in fair use. So this is a process that is actually a non-legal process. We believe we are in the process of changing the law, but changing it through practice rather than through policy reform. So we are making people aware of what the law permits them to do. Secondly, making them aware of the consequences of not using what the law permits. The consequences are quite universal. It's self-censorship. It's people deciding whether it's you doing a website or you providing materials for scholars or whatever other choice you may make. Well, maybe I shouldn't do that. Maybe I should just not go ahead. And maybe you're not even checking with anybody. Maybe you're just making a self-censorship decision. So that's the nature of the problem. And finally, creating some consensus around what this community needs in order to do its job. In other words, linking mission, what we need to create new culture, what we need to get on with our work, what we need to do what the law wants us to do to make more stuff in order to in using this law in order to do that. So we've worked with a number of communities. The very first one was documentary filmmakers, and you guys have a collection of some of these documents. The Documentary Filmmakers Code looks like this. We have a variety of documents that have been created by and with scholars. Two of them we helped to create. One of them was two were documents that film scholars created to help them both teach and publish, to do research and publish. Another document was communication scholars, which the communication scholars found the film scholars' document on teaching so helpful that they said, we don't even need to create one on teaching because we'll just use that one. But they felt that they had research issues that the film scholars hadn't touched on. So they created a code of best practices in research. And the Visual Arts Association has created a document that's appropriate for art scholars. That was not done with us. We've worked with media literacy teachers in the K-12 environment, particularly in middle school. Teachers who work with popular culture, and they routinely teach about it, but their librarian, their media specialist, their principal, or perhaps the Board of Education is saying, well, you can't use anything in the classroom that is not from our dedicated website or from your library. What are they going to do? A lot of times their library hasn't bought a new book for the last 10 years. People who create dance collections came to us and said, we need a code of best practices because we have a lot of ephemeral materials that are purely visual. The future of dance depends on people being able to look at this stuff, but we have a museum buried in upstate New York, and you'd have to get there, and then you'd have to look at this stuff there, and really, is that what we are telling anybody who wants to know what choreography looked like in this period to have to do? What can we do to use fair use to be able to make people in the dance world have access to our materials? People who make open courseware. People who make open courseware, that's like MIT and Stanford and all these people who are now doing MIT X and all that stuff. They wanted to be able to share materials with the world, all these teaching materials that people create, and their universities and their professors were like, hey, I just want to give it away. That's great. Problem, their professors, most of them, are teaching with copyrighted material. Oh, well. What are they going to do then? They can give anything the professor wants that created away. They can't give something that the professor is using that belongs to somebody else away, can they? Well, they're going to be stuck having to use their fair use rights, even though they're completely committed to an open access Creative Commons regime where they give everything away. How are they going to negotiate that? They needed to be able to figure out what was an appropriate fair use. And you in the back from the State Department really want to look at that one. Librarians. The Librarians Code looks like this. It's lavender, like everything else that ARL has ever done. This is the latest document. This is the one that we so depended on Brandon Butler and our great friends at ARL to work on, and we want to share, and I'm sure Brandon will do this, some of the exciting news, not only about what the code says, but how librarians are rushing to put it to use. Some of the questions you've heard today, including from you, about what do I do, some of these questions are answerable within this document, but librarians are constant users of fair use. It's very difficult to figure out something that a librarian is going to do in the course of their day that would not involve fair use. So this is a really core problem for them, and this document has made a huge difference. And now we're working with journalists, who are the most interesting population I might have ever worked with, because they didn't know that they needed fair use. Their attitude is, I don't need no stinking fair use because I have the First Amendment. And tragically, the reality is that their First Amendment rights, when they deal with other people's copyrighted material, which is every day, are actually instantiated in the fair use doctrine. The reason they don't know that they're using fair use is because a lot of these uses were built into the newsroom by company lawyers who just never bothered the pretty little heads of journalists about the realities and just said, you can go ahead and do that. And so journalists are fearless users of copyrighted material whenever they don't know that they're employing fair use. And the only problems they have is when they move into new environments like online, like digital, like multimedia, like we would be doing every day these days, and then they don't know what to do. So we're working with them. It's thrilling. I can't wait. I want to tell you a little bit about this document because it's the first one. It's been out the longest, and it has had the most, it's the one in which I can tell you its effectiveness the quickest. It's been out since 2005, and this was partly because it was the first, and we were unable to say to documentary filmmakers, oh, this is a great strategy. We know this strategy will work. We were able to say, well, we think this was a really good idea. I mean, Peter Yassi thought it up. How bad could it be? But frankly, there's no guarantees. And they were like, we have no problems employing fair use. We would love to use fair use. We just have a whole bunch of people who keep saying no to us, like our lawyers, our broadcasters, our cablecasters, and every distributor we've ever talked to who says that no, they're not going to take our work if everything in it isn't cleared. And by the way, we're documentary filmmakers. They call them clearance Bibles. Our clearance Bibles are like 400 pages long. So why don't you talk to all those other people? And we were like, we'd love to, but actually what they want to know is what you think is appropriate for your needs in order to make documentary film. If they know that, that would lower their risk. It might not be that they would still accept this stuff. We don't know that they would. But they would have a reason to accept it more often because it would have lowered their risk. And what they're worried about is not making good art. That's what you're worried about. They're just worried about the money, they're worried about staying out of trouble, they're worried about getting the content. And frankly, there's a lot of people who are willing to make stuff. You want to make good stuff. So we think that it's on you to say what you need. So what happened, and this happened almost immediately after the document came out, was that films were picked up for distribution that were chock full of fair use and that would never have been able to be picked up before for distribution. They were picked up for public TV, for cable TV, HBO, for IFC. The new kinds of films were made. People thought about making more films that involved compilation and archival footage. But probably the single biggest news in this, from the viewpoint of anybody who wants to know, does this really lower my risk, is what errors and omissions insurance agents did. Errors and omissions insurance is a special kind of insurance you get for some media products and basically all documentary film for any that has any distribution. What that insurance says is, I will insure you against mistakes you made, whether it's about privacy, whether it's about libel, whether it's about copyright, whether you fail to get insurance on your equipment. You can insure for a lot of stuff like hurricanes and everything. So like you can roll, it's errors and omissions insurance into, this errors and omissions insurance touch upon copyright. For at least the last 20 years, nobody in the errors and omissions insurance world, which is incredibly tiny, at the time it was 4 companies, now it's 5, all of them agreed that under no circumstances would they insure against fair use. They were like, hey, go ahead and fair use that stuff, but we are only insuring stuff that you cleared. Now, I'm not even going into how bizarre the insurance business is if they will only accept zero risk documents in order to insure you against risk, but that was their policy. And after this document came out, within a year, within 8 weeks after the document came out, 3 of these heavily fair use films were actually picked up at Sundance. It was those films within a year that received errors and omissions insurance for the first time for massive amounts of fair use. These days, you get errors and omissions insurance. People do not hesitate to accept fair use claims if they were made under the terms of this document. This document allowed errors and omissions insurers to accept fair use claims. They now don't charge you any more for accepting the fair use claims than they would if you cleared everything. So they clearly don't think they are accepting any significant risk by accepting fair use claims if they were done so within this document and a lawyer said so. So the most amusing thing to me is that you can now go online and see lawyers' advertisements that you should come to their office because they really understand how to lower your clearance costs with fair use. And one of these advertisements has the lawyer himself looking through this document and circling the good parts. I'm like, yes. Okay. So I'm going to go quickly through some of the successes with the other ones, and I would be happy to balance this by telling you the failures, but I haven't heard any. Okay, so what happened with it, there's still a lot of people who don't know this and might not use it, but that doesn't mean, what I haven't heard is people from content industry saying this is a bad idea or challenging it or having any lawsuits that say, you know, this is an irresponsible document. So what happened when media literacy teachers got this document? Well, suddenly you've got student contests for video that they're saying, they used to say, oh, you have to clear all the material in this, or it all has to be original. Now they're saying you have to do that, or you have to have exercised fair use and show us that you did according to this document. Teachers were unable to share their curriculum because they wanted to share a smart idea, but they didn't want to put it up online. They would not get a publisher to accept the terms. This stuff was like samizdat, you know, it would be slipped at conferences, one to another in Xeroxed formats. Now they're able to they post this stuff online and share it. People are developing new kinds of textbooks and multimedia textbooks, and the excitement for me is school boards are actually changing their policy and building this language straight in to their new policies, language from this document, and they're building it in Baltimore Public Schools is one of them. The dance collections people, when I'm showing you a page from a web page from Jacob's Pillow. This is a site that would have been impossible before they created the code. You can go to danceinteractive.jacobspillow.org and you can click on artist, genre, or era. You can see video of this artist's dance, of dance from this era, of a particular genre, and that video comes with commentary and a little bit of a description that allows you to understand why this is exemplary or important in the history of dance. Any student anywhere, any dancer anywhere can now get access to stuff that was buried in an archive before that they couldn't have even probably traveled to. What happened after the people who make OpenCourseWare developed their code? Well, MIT, which had a bunch of courses up online already, immediately went to work putting this code to use, and within one year had 31 new courses that had been off the books completely because they had copyrighted material in them, now available to the world with all the copyrighted material properly labeled. And now here comes the good part, librarians, which I'm going to save for Brandon to talk about, who's coming right up. So the lesson that we have learned here is that in fair use, practice makes, what does practice make? It usually makes perfect. In this case, it makes practice. Okay? We would love you to use fair use if you only want to take a part of this. Otherwise, tell everybody the whole thing. And you guys, everybody at AU knows where we are, but for anybody else, we're still online. Okay, Brandon.
Thanks, Pat. So let's see. Here we go. Boom. So I'm going to talk to you a little bit about the latest iteration of this project of developing codes of best practice, which was when it was wonderful. I actually had been working at ARL for like a couple of months when we were able to get funding from the Mellon Foundation to support the development of this code. And so I was promptly introduced to Pat and to Peter, and I started reading all the past codes and sort of licking my chops to get into this stuff. It is hands down the most exciting thing happening in copyright law right now. So we've written this code, right? The Code of Best Practices in Fair Use. It's a mouthful for academic and research libraries, right? And the first thing you should know about it is that it was created by librarians, right? Like all of these codes, it comes from the community. We spoke with lawyers early on as we were planning this thing, and a couple of them every now and then would just joke sort of, look, we could do this, right? Just get in the room with me and a couple of my buddies and we'll write the code in about an hour. It'll cost about as much as spending 2 years talking to librarians, but it'll go a lot faster. And that's not the way these things work, and that's quite on purpose, right? The point is to discover really the values in the community and let the practices that emerge be grounded in the values of the community and the mission of the community. So that's what we did. We talked with 90 librarians from 64 different institutions in 9 4-hour discussions. So we got together with these small groups, between 8 and 12 people at a time, all over the country, all different kinds of librarians, right? Folks at big places you've heard of and folks at small places you haven't heard of. Folks doing jobs that have been done at libraries forever and folks doing jobs that don't exist at most libraries, really cutting edge stuff. All kinds of folks doing all kinds of things. And we got them together and we asked them a very specific kind of question, which is not tell us what you're doing and we'll just take an average, right? And describe the lowest common denominator. But tell us what you would do, right? Knowing what you know about your mission and knowing what we can tell you about the law, the stuff about transformativeness and appropriate amount for that new purpose and so on, talk with us now about the problems you face and apply those big ideas from the law to your mission and to your own community. And we presented them with the kinds of scenarios that we knew they were encountering over and over again in their practice. How do I handle those crusty old VHS tapes when we don't have a VCR anymore? What do I do when a professor tells me to put something on reserve and it's an entire journal article and so on? And we put those questions to the community and found a consensus across these discussion groups. Now, when that consensus emerges, as in all of these documents, there's actually a kind of a legal review process that takes place where, frankly, that's just a kind of a seal of best housekeeping seal of approval that says, no, they have not wandered off the reservation, right? These folks are not totally insane. The world of fair use is funny. I think it's sort of like the afterlife. Every lawyer has his vision of what the perfect fair use argument looks like, and no one can agree on the truth. And so you could not get 5 lawyers to say, this is perfect, like this is exactly what I would do. Out of our own vanity, we have to reserve the right to disagree with something. But we could get 5 lawyers to say, yeah, I'd represent somebody with that argument, right? That is an argument that would fly. That's an argument that I would take up in court. And that's all you can get, really, from a lawyer most of the time. So how does this thing work, right? What did we think it would be used for? And this is actually, we can posit a guess, and Pat and Peter are better positioned to guess than I am because they've been doing this for a while. But it always depends on what really happens is just going to depend on how you all react to this thing. But what we thought about when we were doing it, especially in the library community, was that there's a real problem of seeing the legal risk as the only risk at issue, right? That is, the only question that matters is there a more than zero chance of my maybe getting sued? And if that chance is more than zero, then kibosh on the project, right? And one thing that we found in speaking with librarians, and that, I mean, this is true everywhere all the time, is that there are other risks that are also equally important and in fact often more important than the legal risk, namely the kind of risk to the mission of foregoing a valuable and important project, right? So, I mean, the paradigm case that I can think of in terms of maybe apparently high-looking risk but really, really high reward, and boy has it paid off, is the HathiTrust project, right? Millions of books digitized, with unheard of potential in terms of accessibility and in terms of facilitating new kinds of research and search across a gigantic corpus. Now, at the time that this project was undertaken, was there zero risk? You bet there was not zero risk. There was some level of uncertainty, but frankly, I don't know an attorney who could look you in the eye with a straight face and say that the fair use argument isn't pretty darn strong for this thing, actually. It looks risky because it's large scale, and it's unprecedented in the sense that no one's ever done exactly this before. But what we know about the court, what we know about the case law suggests that this is a good thing. This is the kind of thing that can win. And it just won big in the Southern District of New York. The HathiTrust case was a winner for libraries and for the print disabled and for the researchers who used that. And there was a real, you can ask anyone who was involved in this litigation. There was a calculus involved here. The risk is non-zero, but boy, what about the reward? And part of the idea of all of these documents is to sort of remind you about the reward and the importance of the mission and how taking advantage of your fair use rights, even in the face of some uncertainty, some inevitable uncertainty, can really pay off. And relatedly, to make sure that the views of librarians get into the room. So we were told time and again of these horror stories that, we have an idea and we sort of write it down and then it goes up the flagpole and somebody tells us whether we can do it or not. And there's really, you are never in the same room as the lawyer who says no to you, right? And the idea here was that, if you're not in the room, then this thing is in the room, right? And this thing sort of speaks for your community. And we've heard some of the earliest feedback, and the earliest positive feedback that we got was, even though it was tentative, was, for the first time I gave my counsel something and their face lit up and they put it on their, and they kept it, and they're like excited to use it. And that's good. That's a really good start. And the final thing is we hoped it would be a grounding for solidarity. Right? And in fact, I talked to someone who was involved in the conception of this particular iteration of a project, a library director who was there when Mellon decided whether to fund us or not, and she said, do it. And one of the things that she had in mind was that libraries are all doing stuff in their little cubbies and they don't want to tell each other what they're doing because they're scared that what they're doing is wrong, right? And so, like one of the things that we heard repeatedly was, well, we don't know if what we're doing is fair, but we do know that we put that sucker behind a password, and we put it behind a firewall, and so no one will ever know what we're doing, and it doesn't matter if it's fair. And so part of what this document was meant to do was to get people in a room, promise them confidentiality, and let them start talking again openly. And now that we know when people speak openly and honestly and in an informed way how they feel. And so we've tried to break down those barriers between libraries who were not talking to each other about their values. And now it's time, frankly, to rally around these things. And especially with the HathiTrust case, the Georgia State case, the UCLA case, the tide is turning in your favor. It's time to get on the surfboard and ride. So let's do it. So if you look in this document, whoa, there's a lot of stuff in there. There's 8 principles in there. Oh, well, that gets a lot louder when I put it closer to my face. There are 8 principles in here, and there's a very detailed rundown of a background of fair use, and then each principle is accompanied by limitations and enhancements. And that's really important. And this has always been true. There have always been limitations. We added enhancements this time around because librarians are so darn conscientious. It turns out we couldn't they could never stop at good enough. They always had to say, well, and wouldn't it be great if you also did this? And you're like, well, okay. So these are things in the enhancements category that are not required in order to sort of live up to the aspirations of what would be fair within the community, but go kind of above and beyond. I wanted to use the word supererogatory, but I was told that was a big word, and I don't know. I have high expectations of librarians. So these things are intrinsically linked, right? The principle can't stand on its own. Each of these principles is actually pretty broad and bold, and that's on purpose. I mean, it actually is. It serves a kind of rhetorical purpose of getting you to see that there is a big, broad category that librarians say there is fair use in this big, broad category. But that big, broad category, of course, requires some articulation, right? There are boundary conditions. And so the limitations give a kind of outer bounds to each consensus. So the limitations are absolutely essential. That's really where the meat is in terms of deciding whether you're within the bounds of your consensus. And as I said, enhancements are supererogatory. So there are 8 principles, and they deal with these 8 big areas, right? Posting course material to electronic platforms, that's course reserves, Blackboard, that kind of stuff. Creating exhibits, both physical and virtual. Digitizing for preservation, and I should update the slide or change it because it's also for access. But with respect to materials that are fragile, obsolete, near obsolete, and so on. Digitizing special collections, again, potentially for access, also for preservation. Access for the disabled, big part of the HathiTrust case. Institutional repositories, libraries manage those repositories, and there's a principle in there that describes how better to do that. And then non-consumptive research, which is a fancy legal term for the kind of thing that Google Books does and that Google does, where you're not really reading the whole book. What you're looking for are facts about the book. How many times does a certain word appear and on what pages and so on. And then finally, web harvesting, collecting those websites that are going to disappear if they're not collected and that libraries are anxious to collect. So I'm not going to go through all of that with you, but I want to talk about a couple of examples. So the first example, this is a special collection that was digitized. It's a kind of hybrid example because it shows you both digitization of a special collection and also creating a virtual exhibit. So this is a collection at Columbia University. It's about a man named Alexander Gumby. And Gumby was not made of clay. He was a man who lived through the Harlem Renaissance, and he was an obsessive collector of clippings of everything going on around him at the time. He sensed, rightly, that this is important stuff. And so he has these many, many notebooks that are categorized and indexed and cross-referenced, and they contain, clip outs of advertisements, they contain poems, they contain newspaper articles, and this is a kind of chronicle of his time through a heavily personally curated series of notebooks. And Columbia, of course, got these notebooks, and every librarian is going to feel my pain here. They didn't get any rights with the notebooks, right? I mean, this is always the story. Somebody comes and says, let me give you this wonderful gift. I have it, and now you have it. And all you get is the stuff, the physical stuff. But if you're a librarian, and especially if you're a librarian who's ever had the maybe fortune of talking to a lawyer, having the stuff is like less than halfway home, right? You need to be able to tell a good story about the rights to the stuff, because Alexander Gumby didn't write all this stuff, right? And so whoever did write it may come knocking one day, right? And the fact that Alexander Gumby said it was okay will not mean anything to that person. So, and yet here we are, right? Columbia has digitized these notebooks, and you can peruse them. I mean, you can't sort of browse all of them willy-nilly. They've done some curation, and that's part of what makes this an exhibit, and that's part of why there's a nice story to tell about transformation. They're talking about Alexander Gumby. They have this very nice narrative that runs alongside of the notebooks to explain where the notebooks came from and how they were collected and how they're being preserved. The notebooks are organized and placed in context with relevant material that's outside of the notebooks. So there's a lot of stuff going on here, and there's a really strong fair use story to be told, and all of this is in accordance with the Code of Best Practices. Another good example, and this is a special collection that has yet to be digitized or put on display, but boy, talk about a problem. MIT is, for good or ill from their point of view, has been bequeathed the personal effects of Noam Chomsky in his library and pretty much everything in his house, which, as you can see from this little excerpt from Google Books, is covered from head to toe in manila folders full of junk, right? Chomsky was this kind of crazy, he subscribed to everything, as he says, who has time to go to the library, which, boo. But he subscribed to everything. He would clip stuff out. He would trade things. He would mail clippings, like, to other, sort of radicals and non-radicals and say, did you see this in the Times? And all of this is saved. It's organized. And people are going to be interested in that, right? But obviously, Chomsky is not the New York Times. He's not the publisher. He doesn't have any rights in this stuff. And again, MIT has it. What can they do with this stuff? How can they make it searchable? Can they digitize it? Can they OCR it? How will people find it? Is anyone going to want to wade through the physical boxes of this stuff? And if they have to do that, will they ever get any research done? So these kinds of questions are hugely important, and the principles in this code, I think, will be really helpful to folks in that kind of a position who have to make sense of when and how to digitize and what their rights are. So again, fair use will beat you over the head with this. Practice makes practice. It's like a muscle. That's the other good cliche. I've added to extrapolate onto the cliche. This is your workout manual, right? These are the exercises you must do every day, or else your fair use will grow flabby and weak. Now let me talk about a couple of, oh gosh, this did not survive the migration from Keynote very well. So let me talk about two court cases real quick that I think are highly relevant because they, in many ways, ratify these documents, which is fabulous. It's the only thing I could have asked for, and we literally did ask for, but didn't get, is some kind of footnote, right? I want a reference, because you're clearly talking about the librarian's code. Can you just give us some credit? We didn't get any credit, but so in the Georgia State case, there is that was a case about electronic course reserves. So professors at Georgia State were asking their library, scan this stuff, let my students view it online. And they weren't paying anyone permissions. They paid $0 in permissions. That's part of why they got sued. The Copyright Clearance Center notices when you don't give them any money, and then they come knocking. So there was a lawsuit brought against Georgia State. And the Georgia State opinion is a mixed bag. I mean, it's mostly mixed in our favor. It's a delightful party mix in our favor in many ways. So I want to highlight the positive things. So the decision agrees with us that the purpose of these course reserves type uses is core fair use, right? I mean, this is nonprofit, educational, comment, criticism. It's as good as it gets under your first factor. These are not course packs. That's the other big thing that needed to be said. And, frankly, it wasn't a foregone conclusion, right? The publisher said, look, this is just a course pack. And we had a question earlier about packets. And traditionally, and this is just something that has happened, we, as Peter likes to say, we don't want to refight the course pack wars. We could, but we won't. It's just come down that people pay licenses for course packs. And part of that, you can imagine, is because there's an intermediary who makes some money, right? Kinko's. And there are these cases about those course packs. But what we argued in the library community was when a library does this, not for profit, and directly coordinated with the faculty member in the service of the nonprofit educational mission, that's different. It's not Kinko's making a buck without sharing that profit with you. It's the library helping to facilitate the educational mission, and nobody's making a buck. That's very important. So, court agreed with us there. Tailoring to the audience and purpose, very, very important. She reiterated that 3 times, both in the opinion and again in her order. You've got to think about how much you're using. It's that second thing that Peter talked about. Be transformative and think about how much you're using. And that's strongly in this document. It's also in the Georgia State case that you should make more modest use of works where students and faculty are your core audience, right? We specifically call out textbooks as obviously the core example. You're not doing much transforming if the reason the thing you're using was written is to do what you're doing, right? You are their market in that case, and you're probably not going to have a very sympathetic judge. This judge would not say, because she's responsible and there weren't textbooks in front of her, explicitly don't use textbooks, but she all but said don't use textbooks. And the books at issue here were, in her mind anyway, very nearly textbooks. They're books whose primary audience is just grad students and upper-level undergrads, and that swayed her mind. We might disagree with that characterization, but if you grant her that premise, that runs along with what's in the code. Something important, though, that distinguishes the Code of Best Practices that we developed from the opinion in the Georgia State case is that the Georgia State opinion is only, I can't say this enough, it's only about scholarly books. It is only about scholarly books. If you are asking, what can I do with a film? What can I do with an image, a slide image from my art history class? What can I do with a piece of nonfiction, with a piece of fiction? What can I do with an advertisement from a mag? She didn't touch any of those questions. And so the Georgia State case, and the framework that she has sort of is obviously absurd when you try and apply it in those cases, right? Because she says, well, it needs to be one chapter or 10%, whichever, depending on how many you obviously can't talk about chapters and percentages like that when you're talking about a 3-minute pop song or something. So the Georgia State case is very limited in its applicability. And the final and very, very, very important thing to note is that it's early days for the Georgia State litigation. It's been appealed by the publishers who sued, and so we may see, I expect to see, an even better opinion out of the circuit court on appeal. So when people ask me, should we be changing all of our policies so that we do exactly what the judge said in Georgia State, I think that would be a big waste of time because, frankly, everything's up for grabs and it could change in less than a year. So that's the Georgia State case. Boy, onto a bigger victory. The HathiTrust decision. So, as I said, HathiTrust was about tens of millions of digitized books that were used for 3 purposes: serving the disabled with accessible copies of the print materials that were in library collections, preserving those materials, right? I mean, if there were a Great Fire of Alexandria, this stuff lives on like 7 different server farms in 7 different parts of the country. And then finally, search and text mining, right, to facilitate new modes of research. The example that was in the brief, which I think is a nice illustration and that the court actually described in the opinion, so you know you did good when the court starts taking your examples and using them, is you can do a search on when people stopped saying the United States are and when they started saying the United States is. And it's right there, just the Civil War, right? We were a bunch of states in a plural, and then after the Civil War, we became one United States of America. And it's extraordinary the way you can plot this across the corpus, and because you have a huge corpus, and only because you have a huge corpus, you can conclude with some certainty, facts about culture from searching across these books. Now, these are Principles 3, 5, and 7 of the Code, right? They have been ratified by the courts. I mean, by a court, by a very important court, by the way. This Southern District of New York is the copyright court. It's where all the publishers sue because it's in Manhattan where they live, which was maybe dumb because they lost big time. So, and it's a very short decision. I commend to you to read it. It's like 20-something pages, unlike Georgia State, which is 350. But in my mind, Principles 3, 5, and 7 of the Code are now essentially written into law, at least in the Southern District of New York. So very, very good news for the Code. And again, we have lots of stuff online. There is a lot of stuff, arl.org/fair use. The entire code is online. It's a PDF you can download. It's also online in HTML form, so you can link to particular principles and so on for purposes of blogging and sharing. And there are FAQs, there's video. You can see me do this a lot. I don't know why I do that when I talk, but I did. There's a lot of resources on that website, and also on the Center for Social Media website. Take what we have and multiply it by 10 past codes plus lots of diligent work in the meantime. So there's a lot of stuff online. And that is Pat and Peter's new book, which is here. And available. Underpricing Amazon at $10. That's right. Undercut Amazon. And as we say, share the whole thing. We have our permission, and you don't need our permission to do whatever else you want under fair use. And the Mellon Foundation supported this thing. And the time and energy of research librarians, though, was really what made it possible. Hours and hours and hours and hours and hours and hours of your time, you librarians, made this possible. And that's me. Thank you.
We'd like to invite you to take a short break, and we'll reconvene in 5 minutes for questions.
But that nearly half of the code is. I mean, it's really.
So this is the book, right?
That's the book. Take a look.
Pardon, take one?
Bathrooms are outside the room to the right if anyone's looking for them.
I'm not going to go into it. You can get it on Amazon or whatever.
1170 on Amazon.
Cool. Is this, are there any other texts too that would like really cover all the stuff?
I think that you should look at our websites and take a look at the codes.
Right.
All
Yeah.
the codes are online.
Yeah, yeah, because I want to get one as reference, you know.
I think it should be, actually would be a good place to start. I mean, there are lots of law books about this stuff, or at least
Right.
would include
Well,
it, but they're more technical. I think, maybe a little less.
Well, I'm applying for a job in Geneva, and it's for the World Intellectual Property Organization. But it's just as a researcher, you know. I want to be current. I'll be doing just making web pages and helping with reports and stuff like that. I want to be up on this. Right.
Does the job have a particular focus, or is it general?
No, it's world. It's global world. It's not the United States.
No, I know the organization well. I'm just trying to figure
Oh,
out
okay.
whether there's a particular, whether the
No,
job is embedded in a particular.
No, it's working with communications and updating the website, and social media, and also probably about half research in their libraries and stuff like that, compiling it.
One thing you should certainly look at, I assume you'll see pretty assiduous at the existing website. But one of the very interesting important projects is the stuff about traditional expressions.
I know, I'm a member of an Indian tribe. Here, I'm a member of a tribe, and there's a lot of discussion about that.
A huge initiative.
Right, and the UN and so forth.
Well, I think I get specific. So that's something worth sort of reading up on.
That would, I think, help propel me.
And if they're doing this, that's very high profile right now.
They got you in formative years.
There is also perspective from seeing it from the top or the middle or under. Who knows?
Interests of people in access to information. They've just included
Yes. I grew up in Atlanta, but I went to school with people from the north and from the Midwest, so I never really got an accent. And all of my family from the south would be like, "You're gonna have to slow down," No, it's really
people are really the definitions may also extend to other kinds of areas. So labor.
people would call us and pick up the wrong number. People in my dad's family would be like, "I'm sorry, I'm looking for it." Well, yeah, that's my dad. Excuse me.
Also extend to other kinds of areas like
Right. Thank you. Yeah. Right. Yeah, my son is visiting from California. I took him to Tyson's Corner. We wanted to go to the fabulous Tyson's Corner. We went to the game place. He's a computer gamer, and on October 30th, they're having a huge rollout of a game called the Assassin's Creed. The place is open until midnight. Okay, Assassin's Creed 3. And so they have a trailer, and I'm looking at it, and the thing that jumped out at me, the character's name is a Mohawk word, and it's my tribe. So I have sent this to about 4 elders in the tribe and said, do you guys know anything about this? It just jumped out at me. I go, wait a minute, that's a Mohawk word. And so I want to find out, are the Mohawk people getting a royalty for this? I mean, because a lot of people are extremely, probably to the level of being impractical, protective of that. I mean, there could have been a scholar at Syracuse University cooked up the word. You can learn the language and sort of like but it jumped out at me, and I said, oh. So I've sent it to some cousins and the next chief, and I was waiting for the email. He hasn't emailed me back, and I expect fire and brimstone.
I don't think so. Do you think it's a flattering or an unflattering news?
I'm gonna.
Well, it'd be interesting. Okay,
How do you turn this guy on?
All right, folks, we're going to come back in for the question and answer session, and there will be another chance for some of this food and some other food at the end of the program. Oh, got it. I'm going to do, I can pass the mic.
Okay. All right. So I know we had a number of questions. And I would love to, if you think you have your question answered, great. But if not, this is a wonderful opportunity to bring it back. So Wendy, what do you think is the answer to your question? This is Wendy Melillo from School of Communication.
Okay. Because the background involves the nonprofit organization deliberately denying me copyright permission because they don't like what I'm writing, it adds an element where they want to protect their image. And I get that. However, because they've given me a specific directive, do I still fall under fair use if I go and get it from a university archive? I believe I'm still okay, but I'd like to be sure.
So your issue is just I asked them, they said no. Did I just give away my fair use rights? That's your question?
If I go and get it from a university archive, can I publish it? What's my legal exposure? Do I put the university archive?
Is what you're worried about is you already asked them, and they
Right,
said no.
and they've
That's
denied
your
me
issue.
because they didn't like my questions and what I'm writing about in my chapter. And it's a university archive. It's a university publisher. It's Smithsonian, so it's a nonprofit publisher, if that makes a difference for my book.
It doesn't make much of a difference. One of the interesting things about most of this stuff is that although it doesn't hurt to be nonprofit, it's always nice to be nonprofit. It looks good. But really all the stuff we've been talking about, this transformative use stuff, was developed in and operates with full force in even the most commercial kinds of information commerce. So it's a make weight rather than a central question. So this is one of the few areas of human enterprise in which no may actually mean yes, in the sense that, lurking in the background of these considerations, as we were going over them earlier, there's always this question of, well, is somebody going to lose some money as a result of your not licensing this from them? And so no is a great answer, because it means that they're not losing any money, since they've already declined to take your money or even to consider taking your money. The other reason that no is a good answer, especially if it's a no like the one that you got, we don't like your project, and therefore we're going to do anything that is within our power to see that it doesn't go forward, is that actually sort of burnishes your First Amendment speech credentials as you go forward. So we can't answer your question without seeing or knowing a bit more about the use, but we can say that none of the things that have happened to you so far disqualify you as a fair user, and that in fact everything that's happened so far seems to tend to qualify you as a fair user. The ultimate question is, what are you doing? In other words, if you told me that this was a decorative image you thought would look good on the cover of your book, I might be a little concerned. If you told me that this was an image that is extensively parsed and critiqued and analyzed in your book, I'd feel really good. And if you told me that this was an image that was one of many images that are reproduced in the book to illustrate a point you make, but about which you actually don't have anything specific to say in the book, I'd be somewhere in between, although I'd probably be tilting toward you, given what I know about the case law on the issue of illustrative fair use, which is actually pretty strong. So then the question then, let's assume for a moment then that you're satisfied that you can tell a good story, as I was saying earlier, about why this is a transformative use. Well, then the next question is it the right amount? Now, sometimes, and this goes back to what I was saying before, my sort of warning against the urban folklore of copyright, sometimes you'll hear or read or be told that you can never use all of a work, that fair use applies only to partial rather than to complete uses. And that's simply not true. It's another one of these misunderstandings that misleads us rather than guiding us. Again, the question is this the appropriate amount to use to accomplish whatever your transformative purpose is? And often, not always, but often where images are concerned, the whole image will be the right amount. Because whatever point you're trying to make off that image or whatever you're trying to illustrate with that image may not be as clear if you use only the lower left-hand corner. There may be cases in which a detail or something less than the whole image will do exactly the right work, but often that won't be the case. So that's the thought process that you need to go through. We don't have a code of best practices specific to exactly what you're doing, unfortunately.
Actually, we do.
Oh, forgive me, I take it all back.
Wendy is in the School of Communication. There's a document created that we facilitated through the International Communication Association. This is the one I referred to with communication scholars. And it will be very helpful to you not only in what your decision about whether to go ahead, now that you realize that them saying no didn't invalidate your fair use rights, your question is how to use them, right? And Peter's telling you nobody else is going to be able to tell you anything without actually looking at the very specific every single time. But you know what? You can make a really good decision because this is the same thing as your other First Amendment rights. You don't run to a lawyer to say, can I do this every time? You have to do it. So what you need to do is read the code. And that code is going to be superb for you when you get to your publisher and your publisher says, oh, actually we require clearance for everything. You get permissions for everything you're using. Then what you're going to do is go back and say, well, that's no longer necessary. And if you go further and they're still like, well, no, you're going to say, could you please read the document? Please, and they'll say, well, I'm not a lawyer. And you'll say, could your lawyer read the document? I actually have a chain of emails that I think is 59 emails long that was done by 2 of the major scholars in this field with Princeton University Press. And the majority of those emails are involved in saying, really, we think you should read the document. We really think you should read the document. No, it's really important to us. Actually, this Newsweek cover is really important to the scholarly enterprise. Could you read the document? And you know what? Eventually, they got to a lawyer, read the document, he was like, yeah, I get it, okay. So
Lawyers can be surprisingly obliging. I've so far only been pleasantly surprised by our interactions with counsel's offices when confronted by, and confronted is not the right word, when presented with the code, they see it as a gift. they're so happy to have some guidance because there's just not a lot out there.
But you're in a position where you're maybe the second, third, or fifth person to come up with this, right, to some of your gatekeepers. And so you're in a position first of having to educate yourself and then educating other people. And then you're part of the process by which practice becomes normal, right, in which this is no longer just best practices, but it's practice. But right now, we're at a point where anybody who wants to do best practices will probably have to assert them to people who are very used to dealing with what they think of as fair use from 20 years ago.
Publishers are a really interesting group in terms of their receptivity to this stuff, because it's all over the map. Trade publishers have actually been relying on fair use heavily for a very, very long time. Trade publishers have been in the vanguard for decades of establishing, and to give them full credit, paying the money necessary on occasion to litigate these issues. And academic publishers, on the other hand, have tended to lag behind. And perhaps because they aren't so commercial or just plain underfunded, they perceive themselves as being risk averse. The other thing that academic publishers have discovered is that some academics are so anxious to be published that they'll do almost anything. And as a result, they can shift onto you a tremendous amount of work and a fair amount of expense, securing clearances that you may not actually need just so that they can sleep a tiny bit better. So, on the other hand, the facade is beginning to crack, and large academic publishers are beginning to see not only their author's interest, but their own self-interest in taking a different, in having a different take on this stuff. So we're seeing change at Oxford, and we're seeing change at Cambridge, and we're seeing change at Princeton University, seeing a lot of change at Chicago. The question is, what about the next tier? And that's still difficult.
Adele?
Yes, I just wanted to really thank you for this presentation, because finally it made click with me, you know, because I was reading the book half through and trying to understand, you know, the resources and the tools we have actually to, you know, discuss and to, yeah, also to consult with the students and also apply it to your own films. And today I think it made click, and I feel that I have now resources, you know, to go on and decide from case to case, you know, how it is integrated. For example, that photo in the film, and how is it used, and could it be used, you know, under fair use practice? No, that is, I think, was very helpful to me.
But, you know, to speak to your specific point going in, the question about music, that's actually an area in which we think a fair amount of caution is advisable.
I know, I do music films, I know that, and we get all the clearances and etc. And
there may be places in which,
yeah.
One place in filmmaking practice in which the use of uncleared music is clearly appropriate is the situation in which that music is an incidental or integrated part of the scene that a documentary filmmaker has taken. But often people say, well, I've found a song that really, really expresses the mood of my film, and I'd like to use it as my soundtrack or in a critical sequence, just because it captures so perfectly the emotional state that I'm trying to convey. And the general answer to that, as far as fair use is concerned, is, you know, you better clear it.
Well, this is the example that Robin was giving us of the people in the Minneapolis Chamber of Commerce or whoever who said to a whole bunch of different people, would you all sing this song? Because it expresses how much you love Minneapolis. It's just a very popular song. Why don't you guys sing it? All these different people will sing it. Well, they actually chose that song, and they're using it as their soundtrack. And they asked those people to do that, so they kind of ran out of their fair use claims, I think.
Just one more question. Quick question. The video we saw at the very beginning, did they get sued?
No.
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 I mean, that is Disney and all of this, and Disney didn't even
We can't find, in documentary film, we can't find any lawsuits going back to 1995. We can't find any
Nor do
lawsuits from a music company or a movie company. Any
Nor do we
lawsuits on fair
nor do we
use
know
to
any
anybody.
having to do with sort of straight up legitimate mashups. They get taken down, but that's a different story.
Somebody asked about that, actually, the takedown situation. So the Digital Millennium Copyright Act requires that if an internet service provider gets a complaint, copyright complaint, they're required to take it down temporarily, and then the maker gets a chance to say whether or not they think that what they did was infringing. And to say to the internet service provider, let's say it's Google, because Google owns YouTube. You get something taken off of YouTube, or the sound disappears. And the notice comes up that somebody, either there's a content ID match, Google has a bunch of digitized content that it will match and say, oh, well, we found this song on your soundtrack. So boom, it's going to get taken down automatically. Nobody ever saw it. It's a robot that took it down. Or else a robot identifies that material and Universal says, take it down. This is what happened with Stephanie Lentz in 2006. She took a video of her toddler dancing to a Prince song and uploaded it for her family to see, and then Universal took it down, and she was so pissed off that she went to the Electronic Frontier Foundation and said, I want to sue those people because they seriously irritated me. I have a clear fair use claim to this. You know, I'm showing my toddler dancing in the kitchen to this song, and they shouldn't have done that. And actually then the Electronic Frontier Foundation initiated a lawsuit against Universal saying you did not show enough care in your takedown. And that, believe it or not, that lawsuit is still going on.
There was a hearing, it turns out, earlier this month, so we may actually get a determination in that lawsuit.
But the wheels of justice, et cetera. So better for you if you would actually be confident that what you were doing was fair use, if you employed fair use in your work. For instance, Buffy v. Edward, very clear fair use. He has another one with Donald Duck all over it. Disney never touched him. It's called Donald Duck Glenn Beck, I think, and it's Glenn Beck. It's a mashup of those two.
Clever.
And never touched by Disney. But now you've had a preemptive takedown, one way or another, either through content ID match or through a takedown, and you've got to decide was your work fair use? Well, most people these days are not very well familiar with their fair use rights. So then if they do click fair use, then there's a little picture comes up, a little new screen comes up, and it says, okay, we're going to take a look at that and make a decision. A human being will now look at it and we'll make a decision. And usually it goes right back up. But it says, if we put it back up, the content provider could now sue you directly. So like you read that and you're 15 years old and you don't know what your fair use rights are, what are you going to do? You're going to be like, oh, forget it, right? If you do say, yeah, I'm going to go ahead with this, yes, I employed fair use, typically it goes up and nothing else happens, and we, as Peter says, we know nothing, we know no evidence that anybody has ever pursued anybody who did that. But this is the question that you were asking at the beginning. How much trouble will I get in? If you are the 15-year-old, maybe you're not thinking too much about it. If you're you're thinking about not you, CAS, AU, and all the faculty members, you might get in trouble, right? So those are bigger questions. You really like to know what your fair use rights are. Okay, I don't know if people still have questions about takedowns. We have a code of best practices to help you with that.
I also want to thank you for an outstanding presentation, because I actually, 20 years ago, when I taught at SOC, took a course by a lawyer from the Copyright Division of Library of Congress, And he taught us also that ideas and titles are not copyright. Is there any new development in that?
There's not. That's absolutely right. And that brings up another important question. And I don't know if it is the person from the communications department who wants to highlight. Yes, I thought it was you. Yes, you can do that. You can do that, Camille.
Refresh the rest of our memories
refresh
about
your
what it
memory,
is
right.
we can now do.
Right?
Yes. So if you
Yeah.
right, and if
This was on NBC4. Yeah.
yeah, perfectly legit. I mean, the first thing you should know is those things aren't copyrighted. They're too small. They don't have enough expressive content. So the logo of the New York Times is not protected by copyright. It is protected by trademark. But trademark law, thankfully, is relatively sane. So it makes very important distinctions between commercial uses and improper uses and perfectly legitimate ones. And so the kinds of uses that they're concerned about is where you're pretending to be the New York Times, or you're pretending that the New York Times has endorsed what you do. That's not what you're doing. So any idiot in a hurry looking at your website will know that the reason those logos are there is to mark the origin accurately of that material. That's precisely what logos are for. That's trademark fair use, actually. So you're in very good stead.
So I want to go back to you because you had a question about, can I put up faculty work?
Right, it seems obviously that's not. So faculty have an article up and they want to download it from JSTOR or something like that and then post it on their own website. That seems like it's not fair use. They're just evading JSTOR. But
Well, here's where what Peter was saying, what kind of contracts are you signing with your publisher come into play, because it's perfectly possible for the faculty to give away their rights to employ fair use. It's also possible to employ something like the Spark Addendum, which is something that would allow permission to do exactly that, if they will sign it. I have not, in my experience of doing academic publishing, found one publisher who will accept the Spark Addendum. I'm sure there's somebody. But if giving them the Spark Addendum typically makes it possible for them to start negotiating with me. But what's becoming normal is for them to accept publishing a preprint or something like that, or accepting institutional repository requirements, in which case you have some other options because you could link to the institutional repository. But this is an argument, this is something that you could share with your faculty in CAS, saying, we would love to showcase your work, and it's going to be a lot easier if you build that into your contract.
You know, I want to be a little more conditional about whether this could be fair use or not, because as lawyers will always tell you about anything, I think it depends. There may be situations, and they probably will be common situations, in which your faculty member will have other ways, perhaps slightly less convenient, but still available, to find copies of their own work to put on their websites. But I can also imagine situations in which that isn't so easy. I've got some old work of my own that was definitely not born digital and has really never been digitized, and about the only way I can get representations of that stuff is to scan it, and I do, and I make use of those scans. And my view is that, would someone ever choose to challenge me and risk looking incredibly ridiculous for suing me for using my own work, I would have a fairly strong fair use argument, in the sense that I'm now using this for a really, really different purpose. That is to represent something about myself, to portray my career as a scholar from whatever dubious informational purpose it may originally have served when published. Here is something to remember about transformativeness, and it's something that was confirmed in words of fire by Judge Harold Baer in the HathiTrust decision, and that is that in order to make transformative use of a work, you don't have to mess with it. You don't have to change it. You don't have to draw a mustache on it. You don't have to eliminate every second word. What you have to do is to change significantly the context of use. So it all boils down to whether you've got a story to tell. about the context. And frankly, it also boils down a little bit to the question of how much trouble you could possibly get into for using your own work in a context in which, if it were complained of, it could immediately be taken down, which I think is a number, if we were to estimate it as a number, it's a number asymptotically approaching 0. So that said, it's an interesting, complicated issue. There's one other area, though, about faculty work that I don't want to leave any ambiguity about, because I know, because I've talked to them at meetings like this all over the country, that some faculty think that they are somehow barred from drawing on their prior work in their new work when they have signed away the contracts to those prior works. And they should be assured, if at all possible, that that's not the case. They should be assured that although we may or may not be able to reprint the work that we have assigned away, we're certainly in a position to draw on it, incorporate it, and use it as a building block or a stepping stone better for our next publication. So this may or may not be self-plagiarization. I take no positions on the ethical dimension of self-quotation, but I can tell you that from a copyright standpoint, it's non-problematic.
I would be in such trouble. My entire academic career is a remix. Okay, you guys.
Yeah, we have some publications that we are looking to convert to electronic form, and we own the rights to all of the written part, but we have some images that we previously had copyrights for, but we may not have the electronic copyrights for, and this is all done for education purposes, and everything online would be free to the users. Would this count as fair use?
The answer is, it depends. It could. It depends on the relationship of the image to the text. It depends on, once again, the story that you can tell about why that image is there, what argumentative purpose it serves, how that purpose is different from the purpose for which the image is just offered. So just let me give you an example. Suppose that you have a text that talks about demographic trends in the 19th century United States, and you hire an artist to create a graph that illustrates that text, and you license that graph for the next 10 years from the artist. At the end of 10 years, I don't think you're in a very great fair use position if you want to go on using that. Why? Because you're using it for exactly the same purpose for which it was originally created. On the other hand, if you're publishing a history of elections in the United States, and you want to use the wonderful George, let's say a photograph, a contemporary photograph of election night in Times Square, it seems to me you're in a much stronger position because you're saying something about the election as a public festival, which is illustrated by that photo. And if you want to make your argument even stronger, maybe you actually have something to say about the photo. So it depends on the nature of the image and the relationship between the image and the text, and more broadly, the relationship between the use of the image and the overall project.
Peter, I just want a follow-up question from that, because I'm familiar with the situation of documentary filmmakers who previously licensed, perhaps they would be able to employ fair use, but they previously licensed this material. And when they licensed this material, say it's from a footage house, there's a clause in the license that says, and if I ever need to re-up these rights, I will do so under the same terms or whatever. So in that case, could they then say?
Again, one would really have to look at the clause. The clause that you've described, just as you've described it, would not seem to me to bar a switch in rationale for use from license to fair use. But a clause that said, I agree that if I use this again, I will license it, and I hereby waive any other rights to license it that I might enjoy, could have the opposite effect. Fair use rights are fragile. That's why you have to be. They have a lot of. I never remember, but there's something. There are some things where they have. You can lift a lot, but then if you turn them this way, they snap. It's sort of different kinds of strength. And And fair use rights have a lot of strength when stressed along some dimensions and less strength when stressed along others. And their greatest vulnerability, the soft underbelly, if you will, of fair use is its vulnerability to contractual waiver. So yeah, you'd have to go back always and see what did the agreements that have now lapsed say, because they could say something really bad from your standpoint. And if you promised that you wouldn't make future fair use of those illustrations, either in so many words or in words that amount to that, then you're probably stuck with the promise. We hope eventually that the courts may decide otherwise, but so far all the signals we've gotten from them, which are incomplete, suggest that they probably will uphold the contract.
Other questions? Yes. Diana.
Anything in the guidelines that have been developed for anything changes how the law is seen that would leave one have a little more access to orphan works?
Good question. Good question. You want to start, Brandon?
Yeah. So let me start because there's a kind of two-part answer to this question. The first answer, which is my favorite answer, is that fair use is the universal solvent. And so when you are exercising your fair use rights within the bounds of any of these documents, it doesn't matter whether you can find a rights holder or not, right? The rights holder could be, Barack Obama, right? You can't miss him. You know his address. You can find him. It doesn't matter, right? It doesn't matter that he's a high-profile person. So when you are squarely within your fair use rights for other reasons, that will help you take advantage of orphan works, right, in ways that would otherwise be a problem because you don't have to ask permission. It will slice right through that Gordian knot of rights. The HathiTrust is a perfect example, right? They have not one, not two, but three, count them three, really strong fair use reasons for digitizing all those books. If mass digitization is supposed to be this really impossible problem because we need to find those authors, well, nobody told HathiTrust and nobody told Judge Baer. You don't have to find those authors because what you're doing is a fair use. And now we've got tens of millions of digitized books.
Of which a number probably are orphans.
Yeah, of which a huge
whatever
number.
Definition you may choose to use.
Yes, that's exactly right. I mean, there's surely the percentages that John Wilkin, who, by the way, runs the HathiTrust, so he should know, his numbers are pretty extraordinary. I mean, we're talking nearly half of the corpus probably, and even more for foreign books. So the orphan works problem, were it not for fair use, would be extraordinarily significant, but because of fair use, not at all. I'll turn to Peter now.
Yeah.
There's a second kind of stage of this question.
Yeah, and that is that in fair use analysis itself, the fact that something is an orphan, at least in the more or less strict sense of the definition, namely that you just can't figure out who owns it after making a good faith and diligent effort to do so, that clearly is good for you in making a fair use argument with respect to the use of that individual item. Why? Well, again, because lurking in the background of all of this stuff is this idea that somehow there might be money costs to the rights holder from your making an unconsented to use. And if somebody has just dropped out completely and hasn't shown any sign of any interest in commercializing this work and has disappeared, in fact, has no licensing agency and no known address, it's awfully hard to figure out what possible harm they could suffer from your making a library use, for heaven's sake. Now, if I found an old novel that I thought was really great material but I couldn't trace to a source, I might not make a movie based on it if I didn't have a very specific statutory basis directly addressing orphan works on which to do so, because the risk would be high and the outcome uncertain. If somebody were to hop out of the woodwork and say, oh, you made millions of dollars using my novel, well, I might have to pay up.
If you made that movie in Canada, would you be okay?
You know, the Canadian system is so weird that I really can't speak to it. I honestly don't know what my sense is that that particular use might be outside the scope of the Canadian system, but I'm not positive. But the fact is, that, I mean, that's the kind of situation for which we really need a statutory fix for orphan works. We don't need it in the library. We can, it would be great to have it, and I'd certainly take it, but we don't need it. We can do just fine with what we've got. What we've got is fair use.
Right.
Another international question was yours.
Yeah.
So I'm pretty comfortable with HathiTrust pretty much. Code number 7, a good reason for us to create some sort of a database for these scientists to share.
Yes.
My other hat as an interlibrary level librarian, colleagues say that in Europe they're
So let me,
so much more restrictive.
let me understand a little bit more about the nature of the problem. Is it that the material comes from Europe?
Well, the thing is that we'll probably be building this database of articles that they'll be analyzing and synthesizing. And what we were thinking about doing.
Well, where will you be building it?
Well,
There's a server. It's going to sit someplace. Where is it?
probably in the U.S.
U.S. law applies.
Okay, so even if they contribute,
Well,
To this
again, what are they
database?
contributing?
well, we were thinking, because this is going to start with a massive database search. So based on their criteria, they will identify this body of literature that they
Right.
want to look at. So if
And
we
then
have-
you'll pull it and put it in a U.S. server.
Right, so we may have different licenses from different publishers. So if they have access to an article that we don't have, so they may contribute to it, whereas if we have an Elsevier article, we can put in there. So we contribute, so the different individuals can contribute to it. And what my question is, with that sort of collaboration.
Well, I think
is
that
it-
they will have to make judgments based on
Okay.
their best understanding of the local legal situation and also of the terms of the licenses under
Right.
which they are operating about the lawfulness of their making contributions. You don't have to worry about the fact that your material, some of your material may come from offshore sources. So we can't promise a complete absolution from risk for the offshore contributors, but we can make a very strong claim that insofar as the institutional use, that is the building of the database on a U.S. server, we're in very, very good shape.
And when you take a look at the limitations and enhancements in the code, you'll see that it recommends the things that you're going to do anyway, like you're not going to make that available to the world.
No,
It's going to be
like
available
a
to
group
the
of maybe
people.
6 people.
Yeah.
Yeah.
And it's going to be available for the time of the research, and then when the research
The other
is
thing
over-
to know is that in some ways, I mean, you're right. I mean, they do things differently in other places. And their concepts of copyright can be more restrictive unless it's Canada, in which case, in some cases, they're even more liberal. But the most important thing to remember is that no country in the world approaches the United States in terms of the actual or feared risk of litigation. I mean, we are the world champions in that regard. And when Pat and I had done this work on documentary filmmakers, I still remember a conversation I had with a German filmmaker who was doing some very sort of edgy stuff. And I said, well, how can you do this? And, you know, you're in Germany, for heaven's sake, and German law. Well, we know German law doesn't have fair use as such. And he said, well, you know, we do it, we have some exceptions in German law, and we look at them, and we think maybe we comply with them, and we use this stuff, and if it turns out that we've guessed wrong, well, we'll have to pay. and maybe we'll actually have to pay a little more than we would otherwise have to pay. And I said, well, won't you get sued? He said, no one ever sues anybody about this kind of thing. It's ridiculous. Why? Well, at least in part because the lawyers can't make any money there bringing this kind of a lawsuit. The copyright damages in most lawsuits that are brought in other countries of the world yield, copyright lawsuits brought in many countries of the world yield damage awards that American lawyers wouldn't even stop to pick up if they were lying in the street. Yeah. It is trivial, small money. And we, you know, lawyers, they aren't any different for the most part from lawyers here. They don't exercise themselves to go after small money.
And with my ARL hat on, real quick, let me tell you, ARL has published an issue brief on international interlibrary loan, written by myself and a couple of other attorneys who work in libraries. The short version is, don't believe what the publishers are telling you about that. Yes. They're lying about how the law applies to international interlibrary loan. They would like for you to pay for that, and you do not have to pay for that.
We're actually not having problems with them. They were talking about how restrictive they were within their own countries.
That's right, but you're not in their country.
Right, exactly.
Yay!
Yeah.
So if people who didn't get their questions answered, we're delighted to answer them personally and directly in the sessions.
Would you join me in thanking these three people for a wonderful conversation? It's wonderful when an afternoon like this turns out not to be a series of talking heads, but instead engages all of us and each other in the way that they answer the questions in such forthright, common, simple, graphic explanations that allow us to put our fact situation into those examples. There are two other people I want to thank, and they're the two people who thought this up. Catherine Simpson is one of them, and the other librarian who worked with her on this is not in the room right now, and that's Robin Chin Romer, who asked one of the early questions, who was here. The young woman who's been running around with the microphone is Linnea Bauer, who's our events coordinator, and I want to extend my thanks and hope that you will join me in thanking the three of them as well. And we have more food.